Hello folks, and welcome back to the Sovereignty Masterclass. Hope everyone is doing very well, studying very hard and all that jazz. In this brief video, I just want to jump on and quickly share with you some real simple verbiage as to how to add your children as chattel, okay, to either your estate or your foreign grant or trust, okay? And this is simply taken out of Redemption Manual Series 6, Book 1 of 4. They can get over at sovereignfilings.com, all right? And it's pretty straightforward. So I know a few of you emailed me in regards to how do I protect my children. Well, first, you've got to learn all the UCC, securities law, what's going on within the system, okay? And then obviously have the necessary entities set up with your estate liquidated, so to speak. So you're set up as an executor and then as a trustee for your foreign grant or trust, and have the knowledge in order to administer your estate and your trust. That's when you'll be in a position where you can start protecting your children. It's like you've got to put the oxygen mask on yourself first, okay, and learn about all these things of securities, UCC, taxes, accounting, and the monetary system, the law that's happened, right, for everything that's gone on. Have all the necessary entities set up and the knowledge in order to control your securities. Then you can start helping and saving other people, like, i.e. your children, okay? So that's that whole analogy on the airplane. You've got to make sure you put your mask on first before you start going around and, wanting to do things to try and help your children. So you're going to help yourself first, and then you can start helping your children and the other family members in order to protect their conduit, which is obviously their straw man, under either your estate or your foreign grant or trust, okay? And off the back of this, it's very, very simple. Off the back of this, there's about 4 or 5 pages of a read through that I thought was really, really quite good as a conclusion that these guys have put in regards to how we should be thinking moving forward from this point after we've established all of what we've established, right, with the estate and the foreign grant or trust, and now maneuvering ourselves to become that private banker, okay, that true bona fide sovereign, secure party and creditor, entitlement holder, protected holder, etc., right, donning all these caps and titles. That I thought was really, really well written. Otherwise, just summarizes perfectly the kind of games that have gone on and a little bit of a history and obviously what's happened under this coloring, okay, of all these subjects of the currency, the contracts, and now the law. Okay, so just to, prime yourselves off the back of this when stepping out into the big bad world. Now, having the knowledge that you've retained up to this point, if you guys have gone through every single module, you should be, competent and well-versed and very confident in knowing how to navigate this jungle, this colorable jungle that we now live in, all right? There's still going to be a lot of predators. So I just want to read through this because I thought it was a really good read. That's only going to add value to our understanding. Okay, so following is an example of how to add a child which must be under the age of majority via UCC3 amendment. It is not suggested to add additional property or verbiage to UCC1 initial finances statement, as it can cause unexpected issues in filing. Furthermore, adding each additional piece of property separately allows you to enforce the addition of the property separately, giving you greater control of the property and the enforcement thereof. For example, do not add all of your kids and your boat on the same UCC3. Add your kids on one, and then on a separate filing, add your boat. Okay, pretty straightforward. And you've got an example of the finances statement and the verbiage, okay, of adding collateral. The following property is accepted for value, exempt from levy, and herewith filed under necessity for recording within the commercial chamber. And you've got chattel property, which is name of your child, certificate of live birth or birth certificate number with the equivalent of wherever you are of your social security number, with the associated preferred stock number, prepaid account number. Now this is the QSIP number that is normally on the backside of the social security number they issue in America. Other places such as the UK, they don't have that. Okay, so if you can't get your hands on the QSIP number, do not panic, do not worry, you can just take that out, okay, and or try and find it, and or also list down any and all kind of government registered identification numbers and securities that may have been assigned to your child. You can put in this space too, okay? So it continues, note, secured party is the holder in due course of all documents and documents of title listed and attached to financing amendments, all right? You've got here, as a secured party making this filing is the foreign grant or trust in this instance, okay, where you're coming in as trustee. So you've got the actual trust, putting a lien against your child, protecting it under trust with you as the trustee. Okay, then you can also use your estate, decadent estate, where you're coming in as executor. Okay, so whatever one you choose to use, just make sure the private security agreement linked to that entity, you also add your child and a description of the property with all the identifiers of its security under Schedule A. Okay, just put new entry under Schedule A and put it in there too. All right, and that's you print that off, sign it, and then keep a copy on your records, and you'll be able to use that going forward with a copy of your security agreement to show that you are in control of your child, okay, or your child's straw man, as it were, okay, which is the conduit they're obviously using to try and drag, again, your child, whether it's a he or she, into their culpable bankrupt jurisdiction. Right, so if that being covered, just want to move on to this next section and read this through with you guys. It's only, I think, 4 pages, but really, really good just to, again, prepare ourselves, okay, as to, right, now you got all this done. We've still got more things to do, which is really, really advanced in regards to the private banker, getting ourselves in the door of the DTCC and start actually, making secure transactions and accessing, all these bonds and credit on account with our limited exemption that we sent in and set up from these entities that we have set up, right? The Decadent Estate and the Foreign Grantor Trust now moving forwards. Okay, that it's just, I think it's really good to tap into that attitude and what is required, the responsibility and the mindset that is required of us in order to be a success in this. Okay, because unfortunately, this journey, it really isn't for the faint-hearted. You really got to put in the effort. I'm sure we've all been there. I've been there too. I've been tested many times along this journey, but you've got to take each test, in your strides, learn from it, grow stronger and wiser as a result until you become this kind of embodied beast of a sovereign that can't be messed with because you have full knowledge of all of the main facets of this journey, right? Which is securities, UCC, taxes, accounting, okay, and obviously full knowledge of the money game that's gone on with the colouring of the contracts, money, and the law, right? So it says, now you've completed all the forms and documents, etc. Fine. Okay, you're now a secured party creditor. The private banker, you're on the path, and the commercial world is now before you. And in some cases, you're just going to have to step out there in faith. Okay, we're not saying it's going to be easy. There will be challenges as usual, and your education must continue in respect to the commercial scheme. Some people in the past have done some dumb, well, let's rephrase, downright stupid things. They have screwed up and have gotten into trouble, and some have gone to jail for a few hours and some longer. When you do not take the time and diligence, which is your duty to study and understand what you are doing, foolish mistakes will be made. Okay, this comes with the territory. This is also akin to putting your hand in the garbage disposal and turning it on. If you are careful and learn first, act second, you will avoid a great many of the issues you will otherwise face. Learning from others' past mistakes is also a wise move, as we now have all their past experiences to know what not to do that might lead to trouble. Okay, now this is obviously written from the perspective of America, United States, but just replace wherever it mentions the United States with wherever you are in the world as a nation, because you're operating under the same system, okay, which has obviously all been proven with all the presentations that have come before, with the Unidroit and all that, okay, and how everything was pegged to the dollar, then they took the dollar off the gold standard and the silver standard to debase the currency, which debased the law and the contracts, okay, so you get the picture. So just, even though it's United States based, this applies everywhere, wherever your government liabilities are greater than their assets, they're operating under bankruptcy in the same system, okay, of negotiable instrument law, colorable law. So why is it so important I educate myself? Okay, let's look at a scenario where two people doing the exact same things go into the exact same situation. Okay, one with knowledge to back with what they're doing, and the other simply following pre-laid steps they do not fully understand, copy and pasting. Both in the situation, we will assume, have issued corporate bonds, and both have been called into court or before an investigator to explain what they're doing, right? The first answer is the investigator with proper knowledge, information, and full understanding of exactly what he's doing, or she's doing, how it is doing it, and for what reasons, stating rules and regulations as applicable per their code to back what he or she's doing, right? Learns how to administer the estate appropriately. Sure, I accept the charge, I accept the Christ. I've got everything set up, I know exactly what I'm doing. I know the power of my signature, the unlimited exemption, and the codes in order to unlock that, okay? The second, when called in, stammers, stutters, and gives a completely unintelligible answer. The first, as they know, will be a very difficult target to take advantage of as well, that he is most likely doing absolutely nothing wrong. Okay, they simply it's a simple thanks for coming in, shake his hand and wish him well. All right, the second, on the other hand, they create an indictment for, as he is defenseless, lacking knowledge and understanding and ability. So you see two people in the exact same situation doing the exact same things have walked out of the same situation with completely different results. You must ask yourself at this point, which one are you going to be? Are you going to educate yourself properly and take good, intelligible steps to ensure your future? Or are you going to be the stuttering, stammering fool with a court case? So what if I don't have it in me? Can I go back into the matrix? Yes, you absolutely can. You can retreat and go back into the program, i.e. the plantation, as in the matrix. But understand this, if you do, you'll be that debtor, borrower, slave on the plantation. You own and control nothing, own no property. Your lifeblood/energy will be harvested, and you will subject your children to the same grueling servitude and the private code/statutes wherein your children will never be free. Okay, since you are now the secured party creditor and a private banker, you have much to read, learn, study, and apply. It's a lot of responsibility. Not everyone will become or should become a secured party creditor. As you start on this path, keep a couple of things in mind at all times. One, everything operates on a case-by-case basis. And two, there are no guarantees. Scary? Not really. Okay, there's no guarantee when you hire an attorney and go into court that you will prevail, is there? Or on the operating table, when the doctor says, we're going in to explore and find the problem, but cut it out, wish me luck. Or when you hear that knock on the door and it's some government agency and he says, hi, I'm from the government, I'm here to help you. There are no guarantees other than one, your debtor will be taxed until you die. And two, you can't take anything with you when you cross over in leaving this plane. Okay, that you can take to the bank. So you have now been exposed to the commercial scheme as it has been operated against you. You may now realize that there are no constitutions, okay, that they do not operate upon you. That so-called governments are mere de facto corporations. Their so-called oaths of office and meaningless or frivolous formalities to deceive you. That politicians lie. That the so-called American, or wherever you are in the world, way of life today is a society built upon the creation of debt. NationalDebtCalculator.com. Just punch it in Google, no matter where you're from, and you'll see what defines someone who's in bankruptcy. Their liabilities are greater than their assets, and they cannot pay their debts. No one can for this money. So from the debt established, from the hospital giving birth to the new home, the new car, putting your son in college or daughter, the credit cards, to everything in between, so-called governments is no longer there to serve the people, but to control them and harvest their energy through taxes, convert them into customers, take their exemptions, and produce the credit, which is the money for the survival of the corporations. Sounds really more like the Matrix now, doesn't it? Okay, in the past, it was the norm to protest, to fight the so-called agents, to go into their courts and defend your non-existing rights. It was taught to sever all ties with so-called agencies of government, driver licenses, social security, etc., become free, and as applied to IRS and taxes, quit filing, study the IRS code book to argue that the code and its various statutes did not apply to you. But all that was protesting. And as many have come to understand, you go into war, not go into peace. And it's better to pre-plan and avoid these detrimental situations altogether. Okay, that's why we put ourselves in a position where we can just accept the charge. All right, and write it off, set it off. Recoupment, zero the account. And as we now look back, we're in agreement. We can see that protesting and arguing did not get us anywhere, but into more trouble or deeper into the quagmire of more fighting, stress, wasted time, fines, and what was called going to war. And the resulting injuries and wounds can be quite severe. As the trustee or authorized representative and attorney, in fact, of the debtor, it is your function, duty, and obligation to handle, discharge the so-called commercial affairs of the debtor, including but not limited to fines, fees, taxes, judgments, and such other debts, which may or may not arise from time to time. But today, that's not an easy thing to do. It does take some time and a computer. The process can be a little extensive. A record, copies, has to be maintained. Certified mailings done. As we know, the power of any court is in the record. That's a legal maxim. That's why we're establishing our own record under our own hand and seal using the post road mechanics. All right, so much power in that. There may be continued communications within a matter, and there could very well be a dishonor, non-acceptance. The other side may file a court action, okay, to compel payment. Remember, there is no guarantee. As you will come to learn herein, there is no protection either. If you want that, then continue on and keep an open mind as you learn more about how to protect yourself from harm, because no one else will do so for you. Know that the only true protection will come from the knowledge to so use the tools properly and stand on your own 2 feet. Again, we repeat, no one else would do it for you. So everything inside your front door of your home is private. You can do anything you want. Okay, well, you understand within reason, i.e. you can't disturb the neighbors, bury bodies in the basement, etc. However, when you step outside your front door, you step out into the world of commerce. In that world of commerce, your trust/strawman debtor goes before you, and all commerce is done in its name, on behalf of your debtor. Due to the so-called military social construct, known as wherever you are, with everything in the de facto status, everything is bonded, insured, and licensed. Okay, that's bankruptcy, right? Bankruptcy deals with bonds, insurance, and licenses. Okay, and made subject to government franchises. Since corporations are fictions, though they can sue and be sued, they exist under privilege. They are licensed to perform in commerce full regulation of these entities for the purpose for taxation and raising of revenue/profit. Okay, if they were a de jure government where constitutional rights are unalienable and constitutionally protected, licensing and income taxation would not apply to the private man. License is defined as to do that which otherwise is illegal. When did the Supreme Creator direct that his children live under license? Did their so-called forefathers establish within their Declaration of Independence that their right to life, liberty, and pursuit of happiness was subject to license? When was it ever illegal to marry, to go, travel by any mode of conveyance, to work, or to pursue happiness? Would not a certificate of competence be better than a license? The point is, all commerce is done in the corporate activity, name, entity. Once you understand that, the rest of the commercial puzzle will begin to fall into place. Obviously, in the past, you entered into contracts or franchises with companies, corporations, and various government agencies, etc., via, in the name of your alleged debtor or franchisee, controlled by its corporate creator in wherever you are. Okay, once you are a secured party, it is paramount to understand the contracts that you are entering and by what means you are entering them. It is also important to keep in mind also that all franchises are contracts. It says here out of American Jurisprudence, second edition, okay, it's a contract in 1999. It is generally conceded that a franchise is the subject of a contract between the grantor and the grantee, and that it does in fact constitute a contract when the requisite element of a consideration is present. Conversely, a franchise granted without consideration is not a contract binding upon the state franchisee or pseudo-franchisee. Okay, to some of you, this may sound vague from lack of understanding, while others of you will have absorbed things quite well and studied diligently to this point. What we mean is that there are now more than one entity. There is you, the flesh and blood, real life, breathing being, and also the fictitious statutory person, that is the franchisee and debtor that you as a private human are separate and distinct from, but not surety for. Let's say you now received a bill of accounting in the mail, which is a presentment, and it's a request/demand to pay some certain money of account. But first, within this book and other information available elsewhere, you must understand the so-called money issue, as well as the basis of business. Information pertaining to running of a trust is in the second book. If you do not know what you are doing, then read it. Furthermore, if you do not understand what the terms used in respect to money mean, or any issue related thereto, then one cannot accept the facts in relation thereto. Don't go any farther. Either understand the money issue, because it is key to everything, or otherwise redemption is not for you. Return to the plantation and perform under commercial servitude. If you need further understanding, we would suggest reading The Theft of America, Samuel Franklin Smith, available in our bookstore. Being successful is not for everyone. The lazy and unmotivated need not apply themselves. Now, guys, the best book that I've read that explains this concept of the money, okay, is the UCC connection that I did a whole presentation on, and otherwise gone back over it on the UCC Article 2 of sales. And that really just encapsulates and puts in really good layman terms, weaves together the money, the contracts, and the law that has sprung as a result of taking all of these negotiable instruments off being backed by gold or silver, something of substance, okay? Non-redeemable negotiable instruments. And that is the crux, that's the linchpin and catalyst of them being able to then change the venue from the common law of these contracts and purchase agreements and security agreements that are being formed to the colorable amity jurisdiction, which is statutory jurisdiction. Okay, this de facto quasi colorable title holding non-negotiable, non-redeemable negotiable instrument law. Okay, so that is the perfect one. I've got presentations on this, go on YouTube, inside my course. So if the penny hasn't dropped for you yet, buy the UCC Connection book, but go over those presentations, and then the UCC Article 2 presentation that I've done, and it really hit that home for you guys. And it's just a matter of, if it hasn't yet, just keep going through it until the penny does drop for you and you connect the dots, because that it is so very important to realize why we're doing what we're doing, which otherwise I proved in my car insurance case, right? With that surety bond, how securities have now replaced substance as collateral for debt. When you understand that sentence, it means that you've understood what they're talking about here and what I mentioned about the colorable currency, the contracts that were formed under that, and how they had to rewrite the whole law in order to accommodate for the new venue that we now find ourselves in, bankruptcy, securities, okay? So yeah, just to help you guys out. Per their original social compact, party contract, US Constitution, or no matter where you are, no state shall make anything but gold or silver coin a tender in payment of debt. Okay, and per Bouvier's Dictionary of Law, 1839, title, as defined in number 5, states that lawful coin of the United States will pass the property along with the possession. The property and the possession are called the droit and or duplicatum jus, and is defined as the double right. You have to understand that back then, gold and silver was the money of exchange as the accepted medium, and was the substance of money, or what was to back the money of account in the form of any notes or such IOUs, okay, came into existence by and through custom and usages of commercial affairs. As to that point of contractual US Constitution obligation, as from the standpoint that every public servant and officer takes an oath of office to support and defend the said social compact contract known as the Constitution, they contracted to uphold any specific point in reference to uses as to pay any lawful and or legal debts at law arising within or in relationship to such nexus with such jurisdictions established by such social compact contract known as the United States Constitutions appertaining to the several compact party states thereof. Since the conversion from de jure to de facto, okay, the gold was ordered to be removed as a basis of value and substance back in the money of account, and later the silver was removed as well. Therefore, there is nothing of value back in the so-called money of account except your full faith and credit in their fraud today, which is no more than script of a private corporation, okay, which is the Federal Reserve banking system, central banking system, all right, World Bank, IMF, having no value of substance as stated by the central bank system themselves. Therein, when you thought you maybe bought your home or your car, the property, as in the res and the possession title, did not pass to you as absolute ownership. Instead, you became the qualified owner of the property, sharing ownership or control with your government benefactor as a franchisee. And again, like I said, you see Article 2, guys, weave that into, Article 7, documents of title, and the UCC connection. And this, it ties it in so beautifully well. The Emperor's got no clothes on when you understand all those three main concepts, all right, of the money, contracts, and the kind of title that's been exchanged off the back of substanceless money, and the new law that we're now under to govern those kind of contracts and money that's being used to purchase, okay, and contract with one another in commerce. So it says here, we've got ownership, collection of rights to use and enjoy property, including right to transmit it to others, trustees of Phillips Executor Academy versus Executor, the complete dominion title or proprietary right in a thing or claim, the entirety of the powers of use and disposal allowed by law, the right of one or more persons to possess and use a thing to the exclusion of others, the right by which a thing belongs to someone in particular to the exclusion of all other persons, the exclusive right of possession, enjoyment, and disposal, involving as an essential attribute the right to control, handle, and dispose. Ownership of property is either absolute or qualified. The ownership of property is absolute when a single person has the absolute dominion over it and may use it or dispose of it according to his pleasure, subject only to general laws. The ownership is qualified when it is shared with one or more persons, when the time of enjoyment is deferred or limited, or when the use is restricted. Okay, like I said before, possession is 9/10 of the law. It's the other 10th that controls the rest of the res on the planet. Title. And because we're in bankruptcy, every product that's made in every bankrupt nation state, okay, which is your country, because it's under bankruptcy and you're dealing with money on account because they're already in debt, that's not backed by anything of substance, the international creditors are the ones that hold the true allodial title of everything being produced by the debtor nation state, okay, and all the straw men and women that are producing them. And that's why when we go and buy and sell, we think we're buying and selling, our goods. We're only using an equitable title, colorable title, a registered keeper title deed, okay? You're not the true allodial title owner because the international creditors are. And that's where they can then imbue their statutes, acts, and codes in order for you under the express trust indenture to follow. And if you don't, which is part of the contract, if you don't, then they can compel performance, in other words, penalize you, okay, criminally under amity law, which is what statutory law is under bankruptcy, deals in international contracts, okay, where you can be fined for not even injuring a party, okay, who's coming forward I remember the Erie Railroad case, 1938, against Tompkins. That's when they made that switch after they did what they did with the money to then set the new precedent for the contracts and how injuries, damages, and remedies are being sought under this new colorable system, which is the UCC. Okay, again, all explained in the UCC connection book. Okay, it's very empowering to know this off the back of your head and just be able to meditate and understand the whole game that's being played. Okay, so the question is, what do you have access to in the form of money of exchange to pay your debts in law today that has value? And most importantly, if some so-called government agency entity sends your debtor a presentment for payment, is the payment sought in compliance with Article 1, Section 10 of their contract, known as the US Constitution, per their oath of office? If all de jure constitutional value has been removed, then what is left to pay your debts? All that remains is fiat paper currency. However, with paper, one cannot pay the debt. You can only discharge the liability of the assumed debt until sometime in future when the de facto government is terminated and substance is restored as backing for what's called money in paper form, saving the hassle of carrying heavy gold and silver in your pockets, as that would be a bit impractical with some 200 million people allegedly in the US today. So obviously in the past, paper money was created for convenience. Remember what the compelled benefit is? That has drawn people under this clandestine agreement when you're taking the benefit of what the government are offering you in regards to not being sued for discharge, for not paying your debts. Okay, so you have limited liability when discharging your debt, when using the bankrupt scrip, which is their Federal Reserve notes, okay, the central bank notes, non-redeemable negotiable instruments. Okay, and that's the benefit. That's what's hooking us in. And that's why when you go to pay for anything with these baseless scripts, monopoly money, you're not claiming true title because you haven't paid. You've just merely passed on the liability of that debt, which is still accruing interest, to another person for some time in the future when they decide to have a jubilee and bring everything back to substance, which is what obviously the whole debacle around 2001 was all based on with the World Trade Center. They were going to change it back. There's families on this planet that wanted to change it back to the substance-based system, the common law, for these contracts in commerce that had been done, okay, prior to when they changed it in 1933. All right, so that's it's tying into a very, very massive hidden war that's going on with who's controlling and issuing the money supply. So, however, in 1965, then President Mr. Lyndon B. Johnson signed a public law, more aptly put public policy, due to the current military social construct caused by the Civil War, altering the Coinage Act of 1792, and said, as he was signing it, we have no idea of ever returning to it. This is all that one needs to see that the de jure social compact under the so-called Constitution is dead, and the new military social construct operating under the copyright trademark of the United States for the United States of America, as it applied to the contractual Article 1, Section 10, Clause 1, referencing the obligations arising in relationship to payment in gold and silver as lawful tender in payment of debt within the compact party states in the Union style United States of America. And pursuant to the negotiable instrument law, commercial paper as designed is the currency. Okay, so now you know the mission, should you agree to accept it. But understand that there is much more responsibility that comes with the status of trustee, secured party creditor, and private banker. Thanks for tuning in. And as always, thanks for your support. Keep up the good work, keep up the studies, and stay safe out there. And as always, stay sovereign. Ciao for now. Cheers.